Anything that stood out to you that you weren't aware of or that you thought was different from the original thinking? It was all pretty much stuff you've heard before. Or we all slept through the assignment and we just copied and pasted off of a third grade essay we wrote. Yeah, maybe. Okay. Oh, we'll read it. Find out. Let's talk about freedom of religion then. In the First Amendment, this is where we get the idea from. I know that you're all familiar with this already, but the fact that Congress will make no law respecting the establishment of religion or prohibiting the free exercise thereof. The difficulty comes then in the interpretation. And what constitutes establishment of religion or prohibiting the free exercise of that religion, and where is it allowed to be promoted? Where is it not allowed to be promoted? Are a lot of the controversy that comes with this one, and so as you saw in that video, there are a lot of different factors that play into all this. And so if we are going to establish the idea of establishment and free exercise are the two key phrases in this statement, and that is what the court's going to be looking for here. So we're going to examine both of these independently. We're going to look at establishment first. So when this was originally written into the Constitution, the word establishment would have been very obvious to the writers of our Constitution and to our early citizens. They would have viewed it as a state-sponsored type of church, that the government declares this is the official religion and you need to go to this particular church. That would have been part of what they assumed establishment meant. They also might have looked at it as the government preference toward a certain religion and giving preferential treatment toward one religious group over another. And so those have been the two basic interpretations of establishment. And everybody kind of had that same idea that unless it's a state-sponsored church or unless the government is giving preferential treatment, then we have no issue here. And for many years that was the case, and nobody really worried about it. But in our early days of American history, we had established churches. Now, they were not requiring you to attend those churches, but in reality, when we look back on it, there were two major religions that dominated our landscape, and it was the Congregational or Puritan church. Even some of the early colonial constitutions required church membership in order to be able to vote. Well, obviously that wouldn't fly today. But the Congregational Puritan church was a significant one, as well as the Anglican church. Many of the colonies, Georgia, the Carolinas, Virginia, each of those had the Anglican church as their referenced type church. Preferential? I don't know if I might have just made up a word. And at different times, different places throughout our American history, we have seen churches pop up, and they were supported by government laws and taxation, and they were given some preferential treatment. That has happened in our country's history after the writing of the Constitution. So some of the things that we would strike down today have happened in the past. So when we look here, the intent originally was to prevent a national religion. That's what they wanted to avoid. That's what this clause is intending in its original state. They realized that there were different religious preferences throughout many regions, and they wanted to protect those and give you the opportunity to worship in your church how you wanted to without establishing a national religion or national church. The early Congress did certain things that we would never see today, that they would have been very overly religious. They created missionary schools that would have gone out to share the gospel with Indians. They also established a chaplain within Congress. In fact, there's still a chaplain that is assigned to Congress, although it's more of a I don't want to say non-denominational, but he represents many faiths. We'll just put it that way, in many different faith groups. But they still do open up congregational sessions with prayer. It's hard to imagine in our world today, but it's good. When we look here at some more recent interpretation, so the video talks a little bit about this case of Lemon versus Kurtzman, and although it does not show up on the slide, you need to, off on the side or next to this Lemon versus Kurtzman, you need to write in there the Lemon test. The Lemon test is what's used to determine whether or not a law is giving preferential treatment or is violating the religious freedom rule here. And these are the three prongs of that test, of the Lemon test. It's looking at the purpose, the effect, and the entanglement. The purpose, the effect, the entanglement. So it has to have a secular purpose. Okay? So can't have any kind of religious undertones behind it. It needs to have a secular purpose. On the effect, cannot inhibit or promote any particular religion. It has to be religiously neutral on its effect. And then thirdly is entanglement. Does this law have any sort of excessive government entanglement? Are they getting too involved in a religious group? There are rules, there are laws, or I should say laws, that are constantly being questioned according to these three prongs of the Lemon test. And unfortunately, we've had a lot of inconsistent court decisions that have made it more unclear to us because the court has ruled one way based off of who was on the court at that time. They've ruled a different way based on a different court. And so it's all open to your interpretation and your background, and unfortunately it's not been extremely consistent for us. So when we see the phrase free exercise, and again our video pointed out this a little bit, the question here is, can religious belief be accepted as justification of an overt act made criminal by the law of the land? So he used the example in the video of sacrificing people for the sake of their religion. Well, no, you cannot do that. One particular case that went to the Supreme Court in 1789 was Reynolds versus the United States. And this had to do with a particular gentleman out in Utah who was practicing polygamy because of his religious beliefs. And he believed that that was his religious freedom to be able to do that and have multiple wives. And the Supreme Court had this question in front of him. Was he allowed to violate the law of the land in order to practice his religious beliefs? And the ruling in the end of that said that no, he still had to abide by the law of the land. Another question that has often come up here when it comes to free exercise of religion: can the state compel attendance at public schools? Can they force you to educate your children? Or do you have the free exercise to choose to keep your kids at home? And should that be allowed under Amendment Number 1 as part of your unalienable rights? And this particular case here, Pierce versus Society of Sisters of the Holy Name of Jesus, 1925. Oregon had passed a law here mandating that every child under the age of 16 had to attend public schools until the 8th grade, or through the 8th grade. And so they ruled here that the law violated the parents' right to bring up their child in the way that they wanted to. And so they actually ruled in favor of the parents on this one, and that they could keep their child home if they wanted to. But they didn't necessarily set a precedent and determine whether or not it violated the free exercise. So they kind of skipped around this one a little bit, but they ruled in favor of the family on that one. Another question here that came up: does the state have an interest in educating Amish youth to enforce compulsory school attendance? So this is another one that deals with forcing kids to go to school, and this is 1972 Wisconsin versus Yoder. The Amish society has a different way of life, and so they needed their children to come help on the farm, to be laborers. They didn't want them going to school. They were going to teach them at home. And it went to the Supreme Court, and it came down to, in the end, the Supreme Court decided that it was not going to enforce the compulsory education law here in this case because of the Amish community and the way that they are almost entirely separate from the rest of society. So if they force these Amish kids to go to school until they're 16 years old, it's not going to benefit society because they're not really contributing in the same way that a non-Amish person might contribute to society. And so they ruled in favor of the Yoder family on that one.